They were also locked in a bedroom with music playing so loud that it caused the officer's body cam to malfunction. And it was quite clear in the officer's opinion that the reason for that music was to drown out the children's cries.
Normally, when I do these videos, I can give you something to look for, something to listen to that is intriguing or thought-provoking. This just needs to be seen so that you can understand that there is, at least allegedly, definitely evil out in the world. This incident took place over a year ago. It resulted in a year-long investigation. The allegations are extreme against these two people that you're about to see, but give it a look and pay attention to what happened in the hospital with the one child who survived. Pay attention to what the parents did in front of that child. My name is Dan. This is the Courtroom Files.
Mr. Pearson Davis?
Yes.
Good morning.
Morning.
Are you able to hear and understand what the court's saying to you?
Yeah.
Okay. All right. The court calls people of the state of Michigan versus Pearson, Jordash, Davis, Davis. This is case number 26402 FY. I'm Magistrate Stephanie Godsy with the 55th Judicial District Court for Ingham County. We have a multi-count felony criminal complaint to arraign you on this morning, Mr. Davis. Did you have an opportunity to speak with Mr. Capelli from the Public Defender's Office?
Yes.
All right, very well. With that, if the court could have counsel's appearances, starting first with the people.
Good morning, Jennifer Lawton on behalf of the people.
Thank you, Ms. Lawton.
Good morning, Your Honor. David Capelli, Assistant Public Defender, appearing on behalf of Mr. Pearson Davis, who is appearing from the Ingham County Jail over telecommunications. We'll be pleading not guilty to the instant offenses. He has requested services of the public defender, and we will be demanding exam.
Thank you, and good morning to you, Mr. Capelli. All right, Mr. Davis, the court does have a felony criminal complaint against you. That complaint alleges that on or about August 12th of 2024, at a location described as 5940 West Plains Road in Eaton Rapids, Ingham County, state of Michigan, that the defendant did, contrary to law in count 1, did murder VD, the initials of a child. Contrary to Michigan law, this is referred to as homicide, open murder, statutory short form. It is punishable by up to life in prison, DNA to be taken upon arrest. Count 2 alleges that the defendant did knowingly or intentionally cause serious physical harm to a child. Child abuse in the first degree is also a felony punishable by up to life in prison or any term of years. And finally, count 3 is an additional charge of first degree child abuse allegations that the defendant did knowingly or intentionally cause physical and or mental harm to a child, punishable by up to life in prison or any term of years. Mr. Davis, do you understand the charges this court has read to you, as well as the maximum possible penalties?
Yes.
Very well. The exam is demanded on Mr. Davis's behalf. The court has noted in the file that Mr. Davis is applying for the Public Defender's Office. This case has been assigned to the Honorable Richard L. Hillman. Judge Hillman has this case scheduled for 2 separate felony court dates. Probable cause conference scheduled Tuesday, March 31st at 8:30 in the morning. And then 1 week later, preliminary examination on Monday, April 6th at 9:30 in the morning. Do either counsel have anything they wish to address prior to addressing bond?
Not prior to bond, Your Honor.
Not from defense, Your Honor.
Okay, then the court is ready to hear argument on bond, starting first with the prosecuting attorney's office. Go ahead, Ms. Lawton.
Thank you, Your Honor. The people are requesting no bond in this matter. I think that the court rule is quite clear. That's MCR 6.106B, that if the defendant is charged with homicide, that they are not entitled, or that a bond may be denied. These are incredibly serious allegations, and I want to make sure that the court is clear that there are two separate children involved in this. The child who died was 18 months old and essentially died because he was starved to death. There was incredibly deplorable conditions that these children were living in, including a bedroom that they were locked in that was covered in feces, old food, things of that nature. It was impossible to even walk through the house when law enforcement arrived there. Additionally, the children were locked in the room with music that was intended to drown out their cries. That music was so loud that when officers tried to record it on their body cams, the body cam malfunctioned. The child who did survive was 4 years old and was so weak that he was not able to stand or walk on his own, and is quite frankly lucky to be alive as well. When that child was in the hospital following this incident, hospital staff noted in the medical records that the parents of that child, the defendant, would not interact with that child, would not comfort that child, and actually, against the request of hospital staff, would bring food into that child's room and eat in front of the child, knowing that child could not eat because they were then on a feeding tube, essentially kind of torturing that child by eating in front of them. Again, incredibly serious allegations that we have here. I do think that it is appropriate that bond be denied in this matter, and that no contact be allowed with the surviving minor child or his guardians.
Thank you, Ms. Lawton. Do you happen to know the status of any termination proceedings in the case regarding the surviving child?
It is my understanding that the defendant has relinquished his rights to that child. That child is in an appropriate placement now, and it is my understanding that now that that child is in an appropriate placement, he is thriving and doing much better.
Thank you, Ms. Lawton. Mr. Capelli.
Thank you, Your Honor. As Ms. Lawton noted, the court rule is a may instead of a must, so bond could still be imposed in a case like this. I would ask that the court consider a reasonable cash bond. Mr. Davis is presumed innocent of these charges as he sits there today. He reports that he has no prior criminal history, meaning he's always made his court dates. His entire family lives in Ingham County. He's not on probation or parole, and he did report that he was employed. I would ask that the court consider a reasonable cash bond for this matter. Thank you.
May I respond to that, Your Honor?
Sure.
Thank you. Just a couple of things to note. It is my understanding that, yes, the defendant does have family in Ingham County. That family also has, my understanding, significant financial resources. However, did not do anything in this case, was well aware of the conditions that these children were living in, and did nothing to assist those children. Additionally, I do think that for the safety of the public, any bond is inappropriate in this matter.
Thank you. I'll give you the last word, Mr. Capelli, if there's anything else you'd like to say.
Just to reiterate, Your Honor, that Mr. Davis is presumed innocent as he sits there now. Thank you.
Thank you, Mr. Capelli. All right, Mr. Davis, it's important. You've listened to a lot of things being said concerning you, and the court just wants to make sure you understand that you have constitutional rights in this case. You are presumed to be innocent unless you are found guilty beyond a reasonable doubt. You have the right to remain silent, because anything that you state verbally or place in writing could be used against you in a court of law. You have a constitutional right to have an attorney present with you at all court proceedings, as well as if you are questioned by police. You have the right to have a jury trial. I will also say that to Ms. Blatton's wondering if the court was sort of advised in the premises in this case. I am the judicial officer who heard the swear to in this case. I am pretty advised in the premises as to what is alleged here. In terms of bond conditions, Mr. Davis, we're going to go over some of them on the record. This is not exhaustive. We're going to go over some of them, though. If you are released from custody while this matter is pending, you must report to Ingham County Pretrial Services within 2 business days of your release. That is a phone call. You call Pretrial Services. They are the agency that is responsible for supervising all defendants not in custody charged with felonies in Ingham County. Failure to report to them within 2 business days of your release would result in a bench warrant for your arrest. Further, you're not to purchase, possess, or consume any alcohol, no illegal drugs, no marijuana. You are subject to random drug and alcohol testing. You are absolutely prohibited from purchasing or possessing any dangerous weapons of any kind, especially no firearms, no ammunition. You are to have no contact, direct or indirect, with Jack Davis, a minor child, or Andrea Neighbors or Owen Neighbors, who the court understands, correct me if I'm wrong, Ms. Lawton, to be the guardians in this matter.
That's correct.
Okay. Furthermore, you are to have absolutely no contact with any child 16 years of age or younger. Any child. Any questions about those bond conditions?
No, Your Honor.
The court acknowledges that it has discretion in life offense cases, such as this case, to order no bond. It is something that this court does not frequently and with very careful consideration. In determining whether it should be a no bond or something else, the court notes that this incident is alleged to have occurred on August 12th of 2024. I think just over a year and a half ago. There's been no indication that this particular defendant has sought to run from what might be coming. And at the same time, Ms. Lawton, the court certainly understands that there's a big difference between that sort of that interim period where it's sort of just hanging out there with no charges versus when somebody is arrested on, multiple life offenses, charged criminally.
And I would note, just for the record, that some of that delay was due to the extensive investigation that did take place following the initial complaint.
The court is certainly not calling into question law enforcement, the review of the case, the decision, of when to ultimately charge. And the court certainly understands that in a case like this, where there's alleged to be a death, that's a very extensive investigation. More so, the court was pointing out this period of time to show that on behalf of Mr. Davis, there's not anything before the court that I'm aware of, that in that time since August 12th of 2024 through his recent arrest, that he was actively seeking to evade justice.
Understood.
So having said that, the court does not believe no bond is appropriate, but are there very significant public safety concerns? And now that there are 3 life offense charges pending, does that sort of increase the real possibility of flight risk, knowing that somebody's facing that sort of a sentence? Certainly, while the court does not find a no bond to be appropriate, court is setting bond at $10 million cash or surety. Anything additional, Mr. Capelli?
Nothing further, Your Honor. Thank you.
Anything additional on behalf of the people?
No, Your Honor, thank you.
Thank you. Mr. Davis, do you have any questions for the court?
No, Your Honor.
All right. Okay, then that will be all on the record. Mr. Davis, you should be able to walk out of that room and let the sheriff's deputies know that your arraignment is concluded. Are you Carolina Marie Davis?
Yes, ma'am.
Is your first name spelled Karloina?
It was spelled wrong when I was born.
Okay,
It's supposed to be Carliana. That was Sparrow's fault. My parents never cared enough to get it fixed.
okay, so do you pronounce your name Carliona?
Carliana, I just go by Carly. It's so much easier that way. I don't have to constantly explain how to pronounce my name.
All right. The court calls people of the state of Michigan versus Carliana Marie Davis, Davis, case number 26404 FY. Ms. Davis appears before the 55th Judicial District Court for Ingham County via video conference from the Ingham County Jail for a multi-count felony arraignment. Ms. Davis, did you have an opportunity to speak privately with Mr. David Capelli from the Public Defender's Office?
Yes.
Okay, all right, very well. If I didn't say the case number 26404 FY, and with that, if we could get appearances of counsel starting with people.
Good morning, Jennifer Lawton on behalf of the people.
Good morning, Your Honor. David Capelli, Assistant Public Defender, appearing on behalf of Ms. Carliona Davis, who is appearing from the Ingham County Jail over telecommunication. Will be pleading not guilty to the instant offenses. She has requested services of the public defender, and we will be demanding exam.
Thank you, Mr. Capelli. All right. Charges before this court, Ms. Davis, against you are that on or about August 12th, 2024, the location described as 5940 West Plains Road in the city of Eaton Rapids, County of Ingham, and State of Michigan. In count one, the allegations are that the defendant did murder VD, a minor child, contrary to Michigan law. This is referred to as homicide, open murder, statutory short form. It's punishable by up to life in prison, DNA to be taken upon arrest. Count two alleges the defendant did knowingly or intentionally cause serious physical harm to a child. First degree child abuse is punishable by up to life in prison or any term of years. And finally, count three alleges that the defendant did knowingly or intentionally cause serious physical and or mental harm to a child. Again, this is a charge of child abuse, first degree, punishable by up to life in prison or any term of years. Ms. Davis, do you understand the charges this court has read to you, as well as the maximum penalties?
Yes, ma'am.
The exam is demanded on Ms. Davis's behalf. Court has made a note that she is applying for the public defender's office to represent her moving forward. This case is assigned to Judge Hillman, scheduled for a probable cause conference Tuesday, March 31st, 2026 at 8:30 a.m. and preliminary examination on Tuesday, April 7th at 9:30 in the morning. Are there any matters to discuss prior to addressing bond?
Not from the people.
None from defense, Your Honor.
Very well, thank you. With that, Ms. Lawton on bond.
Thank you, Your Honor. These are incredibly serious charges. I think that it is important to note that there are two children involved in this matter, one child who is deceased and another child who barely survived this. The child who is deceased, the cause of death was ultimately neglect. Essentially, the child starved to death. The surviving child was 4 years old at the time that he was discovered by law enforcement. He was so weak that he was not able to stand or walk on his own. A couple of things that are important to note as well. These children were found living in absolutely deplorable conditions. They were locked in a bedroom that was covered in feces, old food, things of that nature, as was the rest of the house. They were also locked in a bedroom with music playing so loud that it caused the officer's body cam to malfunction. And it was quite clear in the officer's opinion that the reason for that music was to drown out the children's cries. I think another significant thing to note is that when the surviving child was recovering in the hospital following this, that this defendant, as well as the co-defendant, offered no support or comfort to that child despite the requests of hospital staff, and essentially just chose to eat food in front of that child as a way of essentially torturing him that he couldn't have that food at that time. Again, Your Honor, the evidence in this case is overwhelming. I will note that the surviving child, this defendant has relinquished her rights to that child. That child is now in an appropriate placement and is thriving and doing much better in that placement. That being said, Your Honor, I do think that a no bond is appropriate in this matter. I think that under the court rule, it is clear that that is something the court can order. That is MCR 6.106B. And so the people would be asking for no bond on this matter.
Thank you, Ms. Lawton. Mr. Capelli.
Thank you, Your Honor. The court rule does allow for Your Honor to impose some bond despite these charges. I would first note that Ms. Davis is innocent of these charges as she sits there today. She reports that she has no prior criminal history. She's not on probation or parole at this time. There's been a significant length of time from the date of when the alleged charges happened until now. There's been no indication that Ms. Davis has offended during that time. I would just ask that the court consider a reasonable bond with the appropriate conditions. Thank you.
Thank you, Mr. Capelli.
Your Honor,
All
if I
right.
could, I'm sorry, if I
sure.
could just address that.
Please.
I just wanted to make sure that the court was aware that the reason for the delay, there was a significant investigation involved in this with law enforcement based on the nature of the charges. I would also point out that this defendant does have family members in the area who do have significant financial resources. However, those family members were aware of the situation that was going on with the child and did nothing to assist in that as well. So just so that the court is aware of that as well.
Thank you. Any response, Mr. Capelli?
Again, just to reiterate, Your Honor, that Ms. Davis is considered innocent of these charges as she sits there today.
Thank you, Mr. Capelli. All right, Ms. Davis, some of your bond conditions are that if you are released from custody while this matter is pending, You are required to report to Ingham County Pretrial Services. That is a phone call. You must call them within 2 business days of your release. That's the agency that would supervise you while you're out on bond while this felony matter is pending. You are not to purchase, possess, or consume any alcohol, illegal drugs, marijuana. You're subject to random drug and alcohol testing. You are not to purchase or possess any dangerous weapons of any kind, especially no firearms, no ammunition. You are to have absolutely no contact of any kind, direct or indirect, with Jack Davis, Andrea Neighbors, or Owen Neighbors. Just to make that clear, no phone calls, no jail phone calls, not in person, in writing, social media, texting, emailing. You're prohibited from trying to have somebody else reach out to any of those 3 named individuals. That's indirect contact, also prohibited. You are being ordered by this court to not have any contact with any child 16 years of age or younger until further order of this court. Court's also going to order a GPS tether that would be required if she were to be released for location purposes. As I stated, when this court just a short while ago arraigned a co-defendant in this case, the court certainly acknowledges that it has the discretion to order no bond. The court never does that lightly. It is aware that in certain instances it is appropriate. The court weighs the factors that it must by law of public safety and flight risk. Mr. Capelli raises a good point. Ms. Davis has no prior criminal history. There's really no record upon which to determine if she has, since there are no prior court cases, there are no prior failures to appear. At the same time, and conversely, she is now charged with 3 separate criminal charges that could keep her in prison for the rest of her life. Does that affect a person's proclivity to try to flee? It certainly can. Public safety is certainly an important factor in this case. While Ms. Davis is presumed to be innocent, this is only her arraignment. The court readily acknowledges, ma'am, that as you are being arraigned before this court today, you are presumed to be innocent. However, I am the judicial officer who heard the rather extensive swear to in this case of what is alleged to have occurred. What is alleged to have occurred is incredibly concerning, to put it mildly. Court sets bond at $20 million, cash or surety. Anything additional, Ms. Lawton?
No, Your Honor, thank you.
Thank you. Anything additional, Mr. Capelli?
Nothing further, Your Honor. Thank you.
Thank you. Do you have any questions, Ms. Davis? All right, thank you. That'll be all on the record. Thank you to both counsel for your appearance.
Thank you.
Thank you, Your Honor.
Hey, thanks for watching. Please do let us know in the comments what you thought of this video. If you'd like to support what we do here, the best way to do it is to pick up some of our merch. You can find it at courtroomfiles.com.